Welcome everyone. My name is Dawn LeBeau. I'm the program officer here with Akitan. Akitan is a native CDFI located on the Cheyenne River Reservation in South Dakota, but we serve native agriculture producers nationwide. So I'm the program officer here, and our mission is to transform native agriculture and food economies by delivering creative capital, leading paradigm changes, and enhancing producer prosperity across Indian country. And like I named before, we are recording this webinar, and I'll just go over a few housekeeping notes. You are welcome to ask questions in the chat, and I'll go ahead and manage those and make sure that our presenter here's those as we move along. I'll go ahead and introduce our partner, Mr. Guido van der Hoeven, if I say that correctly. I'm sorry if I just completely messed it up. He is an agriculture tax specialist with the Center for Agriculture Law and Taxation at Iowa State University. Guido retired as an extension specialist / senior lecturer at the Department of Agriculture and Resource Economics at Northern State University in Raleigh, North Carolina in October of 2019. Guido's extension responsibilities included income taxation of individuals and business entities, farm business management, and the profitable continuation of family firms to succeeding generations. He serves as the president of the Land Grant University Tax Education Foundation, which publishes a 650-page text for income tax training of professional tax practitioners, and also a 222-page text focusing on agriculture taxation. He is married, and he and his wife, Emily, have 4 children and a son-in-law, a daughter-in-law, and 2 growing grandchildren. So with that, welcome, Guido, and thank you all for joining us today. Today's webinar is on the screen here. Is there a succession? Is there an estate plan? 10 common mistakes to avoid. So with that said, I will go ahead and pass it over to Guido to take it from here. Thank you.
Well, thank you, Don, for that introduction, and hello to everybody who is online today, as well as those folks that may be watching this as a recording sometime in the future. And as Don said, the title today is there a succession or estate plan? And we're looking at about 10 common mistakes that I've found over a 35 or so year career in helping families think through the process of transferring their stuff at some point in time in the future. So it is that I am coming with this opportunity, and I thank Dawn for the invitation. Couple of pictures here, kind of looking at it. One is maybe what we would look at as a traditional farm operation somewhere in the United States. And these are the assets. You would have the land and those kind of things. But I think more importantly is the image in the upper right on this particular slide. And somebody has figured out that there's about $30 trillion in assets held by baby boomers. And I think that just depends on what day are you measuring and what exactly are you measuring. But if you just do the simple math, it's about 30 years of time, that transition period. So about $1 trillion a year, just doing a simple math exercise. But really, what does that mean? And you know, trillion is a large number, and for some people that may not mean anything at all. But we also would have, you know, people that do have some things, some of the what I would refer to as stuff. But it's about $1.9 million that gets moved over every minute as somebody may have passed away and moved on. So again, coming from where my experience, 30 plus years, looking with rural families, looking with farm forest management issues. And one of those things is transferring the wealth and if there's a succession plan for this business. And sometimes these issues are difficult to discuss. We face mortality. We want to think as in the context of family, in the context of community, how do we be fair? How is that different than being equal? And one of the things that I've tried to help people think about is, yes, it's a big task. And the analogy has been, well, we're going to try to eat this elephant, but we're going to do it one bite at a time. And that's really what I'm trying to help provide, just maybe a little bit of structure, maybe a little bit of thought process. I'm more than likely, nothing that I'm going to say is going to be exceedingly new, but maybe it's in a format that kind of helps congeal some ideas and maybe motivates people to move forward. One quick picture to think about, and this is how I look at it from the context of a business, and that is, what is it that we're trying to figure out? What is it that we want to see accomplished? So that would be the goals. And you can see here, what do you want your life to be like? What do you want for your family to be in the future? And, what do you want to have happen to the stuff that you've got, those things? Then you look at the other side, over on the left-hand side of the screen, and that is kind of the what do you got, what do you have type of thing. What are your resources? What's cash, what's not cash, what's not liquid in the financial terminology. Land, business resources, it's the stuff of business, the machinery, equipment, livestock, the crops that may be in the ground, whether they be annual crops like corn or soybeans or wheat, or it could be, more permanent. It could be berry crops, could also be timber. And then, are there people that are engaged in the business? Could they be family that are there, or are there employees? And then when we look at the family, who likes the land? Not everybody has that opportunity or has that desire to carry on and work the land. What was their business involvement? Are there any special circumstances that may be engaged or that we need to recognize as we think through some of these planning opportunities? Looking at grandchildren. What about marriages? What about divorces? What about personal debt? Is there a current estate plan in place? And then the last one down at the bottom is looking at plans. This is at the lower right. What do we need? What are there additional resources? We have this thing called retirement. Is that something that is of interest? Do we need to update the estate plan? What about if we dispose of the business? Is there going to be a succession to the next generation, or is there going to be some kind of sale that moves forward? And I think the key here is that this is kind of a circular one. Even though I started with goals and then went to resources and then went to plans, we can start with resources and then go to plans, or we can go resources and go back to goals. It's not just as depicted here, but it does give us a broad scenario of what we are thinking about. So having kind of laid that or set that a little bit as the baseline of where we want to go, or where I would like to visit with, there are 10 thoughts or 10 issues that I think need to come to the fore, that regardless of where we find ourselves, and if we have an interest in estate planning or succession of a business, that these are things that we might want to really focus on and look at. And for those that might remember David Letterman, he often on his show, and this is kind of dates me quite a bit, but he had, the 10 things, or a list of 10 things going from number 10 all the way down to number 1, whatever it might be of the topic of the week or whatever. And so with apologies to him for kind of ripping that idea off, these next items are not in any particular order or any particular weighting, except for the last one, what we'll look at. Some folks may look at them and say, well, this is somewhat simplistic, but I have found over the years that if we can keep the context somewhat simple and then kind of put a little bit of flesh on the skeleton, as it were, to kind of figure this out. So that's kind of where we're going to go and what we're going to do. And as Dawn mentioned, if there's a question or a comment, we can jump in and see how that is. I do want to be say on the outset that I have worked some with Native American communities. When I worked in North Carolina, when I was on the faculty at North Carolina State University, I did work with the Lumbee people down in South Central on a couple of issues. I'm a little familiar, but it is really not one of in my wheelhouse per se. But in the travels and the work that I've done, I found that people are very similar and they have very similar goals. So I think what I'm going to share from here forward does have some applicability to all of us. So looking at number 10, and that is not knowing where the stuff is or what stuff. And it's been interesting for me to visit with families and to help them kind of think through this thing. They say, well, we've got some things, or we have stuff that I've kind of looked at. And in this context, stuff is pretty much a very technical term, but it's the individual themselves. Could be that there's an executor, or could be administrator or trustee. Maybe there are beneficiaries that want to be brought into this conversation. And really, it's looking at what the stuff is. And if an individual is married, then the spouse may have some rights to some of that stuff, unless there is some written agreement or a process to go through. But there needs to be some kind of listing or some kind of accounting for what is that stuff. In the financial context, it could be a balance sheet. Here's a listing. We look at those things. But there could be some things that are lost or forgotten. It could be that there might be a life insurance policy that's out there. If somebody has served in the military, for example, there could be a military life insurance policy that was taken out maybe 30, 40 years ago. It's still there. May have to visit with the Veterans Administration and the Office of Insurance Services to find that. There could be personal property. This could be, vehicles that are titled. It could also be, there could be some personal items, could be jewelry that may have come down from the family or through the family, those kind of things. It could also be just things of the kitchen pots and pans. I remember in my context, my grandmother had gone through her things and had left little sticky notes on the bottom of things. And one of the items was a large pewter plate. Now, I can remember as a child that pewter plate was on her dining room table and always had fruit on it. It had apples or oranges or whatever. But after her passing, they being my mom and her siblings, found that on the bottom of that was a sticky note that said, "This is to go to Guido." And so my mom brought it home. That plate actually is now sitting on my wife's piano. And so I get to see it every day. I remember my grandmother. I remember she put her fruit on it, and we use it sometimes in that way. Then the other assets could be their business property, could be equipment, livestock, and land. What is it that's held? How is it held? And we'll look a little bit more in detail in the next slide. And then today, some of us have these virtual accounts. A lot of stuff is banking done online. We have financial and social media, and there are linkages. What happens to these accounts when the owner of that account is no longer living? How does that get transferred? Who has access to those accounts? How does that get done? The question that I ask, if we were all in a room and I see that, we were talking, how many of us would have maybe a social media account, Facebook or TikTok or Instagram or something of that nature? Those are ours, and I put those in air quotes. But when we're no longer engaged with those items, what do we want done with them? Who has permission to take them down, or are they going to be there forever as a perpetual memorial, if you want to think about it in that context? And that's something to think about. My mother is 86 years old. She has a Facebook account. Why does she have a Facebook account? Because that's how she communicates with the grandchildren and the great-grandchildren. And I've asked her, I said, "So Mom, what happens and what do we do with this? I mean, how?" And she goes, "Oh, that's an interesting question." So, you know, that's something to think about. That's to consider where all of this stuff is and who has it and who has the right to access that stuff. Once those are listed, whether they can be physical assets such as a car or financial assets like bank accounts or social media type of things, those items, you know, now we can move forward and we can say, what are we going to do with it? We can make decisions. The next issue, or the next thing that we want to think about, is looking at property titling. And I'm looking at broadly, we may, and we'll get into this a little bit more, but the big one and where could be is that we have real estate. And how does that, and how is that titled? How is that held? And there are various different ways. And and these may apply in some people's cases. And then there may be, no, this doesn't apply because I find myself in this particular situation. But we have joint tenancies. We can have rights of survivorship, that's the ROS in capitals, or there are some jurisdictions that look as tenancy in the entirety. And this is for married couples, specifically under state law. It could go to the wrong person if the title hasn't been updated. So if there has been, you know, a divorce or something of that nature, and the title hasn't been brought up to date, that person could inherit that particular piece of land should one of the parties pass away, because by operation of law, they'll look at the title and says, oh, joint tenants with rights of survivorship, one party has passed away, then the surviving party gets it. End of story. And that will happen outside of a will. Then we have got common tenancies, and these are where we try to be fair to our children, and we may say, well, we're going to have them share and share alike. And if there's 4 kids, so everybody gets a 25% interest, but that minority interest of 25% could cause a little bit of consternation trying to figure out, you know, I need to sell out, or I want to sell out. There needs to be some kind of method to settle that dispute, or to have some kind of buy-sell type of arrangement. Fee simple, that just looks at it as saying, if I own something in fee simple, then I have all of the property rights. I've got the land, the surface rights, I've got the water rights, I've got the mineral rights, I've got hunting rights, you know, all of those things. But is there a division? Is there an easement on the property? Is there, you know, something that has been stripped out of this property one way or another? How is it owned? Is everybody clear on how this is owned? And then life estates, whether it's granted or retained. If it's granted, then an individual who owns a piece of property grants the right to somebody else to use that property until that somebody else passes away. And then it goes to remainder persons, which could be children of a first marriage, for example. So it could be, you know, dad remarries, second wife, dad dies, the second wife has the life estate to live and enjoy the income off of whatever it may be. But when the second wife passes away, then the children of the first marriage are going to inherit it. They would be the remainder persons. Or it could be retained. I could go ahead and gift the property, but I'm going to retain a life estate for myself so that I can do it. But, you know, some people look at that as a way to do some estate planning through the use of life estates. There are probably better ways to do that. And one is this last one that's looking at is holding property in trust. A trust could be held by the United States for property, for the benefit of maybe Native Americans as a group or a community, or it could also be for an individual. It also, we have the possibility of having it as a trust, as a revocable trust created by an individual to own property with beneficiaries then getting access to either the income stream for a period of time, or the trust can then act as a will substitute and then be able to say it's going to X, Y, and Z. And I am in the process personally of wrapping up my parents-in-law's trust. They had a revocable trust, and after my father-in-law passed away a year ago this month, it became an irrevocable trust, and I was bound by the instructions of the trust as to what's going on. I am not a beneficiary. I am basically the administrator and moving the assets with some kind of communication between the four beneficiaries, my wife being one of those. So we can look at a trust type. Is that the best way? And legal counsel can help sort that out. But when we look here, and I've pulled the next several slides out of, you can see the citation out of the United States Code, looking at trust properties, which are, as we can see here under 4I, it's trust or restricted lands. These are the title to which is being held by the United States in trust for an Indian tribe or individual, or which is held by an Indian tribe or individual subject to certain restrictions by the United States against any alienation amongst parties. Or II, it's a trust or restricted interest in land or trust or restricted interest in a parcel of land, meaning an interest in land. It could be that we have hunting rights or fishing rights or all sorts of different things, but that it's held in trust by the United States for, as you can see there on the screen, the Indian tribe or individual, or by which the Indian tribe or individual is subject to the restriction. Could be heirs are going to be eligible for first or second degree. And again, this is just coming straight out of the code, meaning parents, children, grandchildren, grandparents, brothers, sisters of a decedent. Moving forward. So there could be highly fractionated Indian land. And so here we have parcels of land, because over time, family ownership, if we look at the beneficiary broadly, it's going to look at how many people are part of the family unit, and that may tie or have a right back to a certain piece of property or properties. And that you can see here as well as I can on the screen, got 50 or more, but less than 100 co-owners of the undivided trust or restricted interests. Number one is no such co-owners hold a total undivided interest of the trust or restricted interest is greater than 10% of the entire undivided ownership of the parcel, or if there's 100 or more, that there are some restricted interests that are applied to that. And this is where, if this is the circumstance, then in putting together a plan to either recognize who in an individual's family would have succeeding rights, this is very important to have nailed down and to obtain legal counsel to help with that. Continuing on with further definitions, looking at who eligible heirs are. And I'm not going to bore you with my reading skills, but you can just see here that it's children and grandchildren, great-grandchildren, and so on that are Indian or have lineal descendants with 2 degrees of consanguinity of an Indian, or owners of a trust or restricted interest in the parcel of land. And then there also needs to be looking at, we don't want to waste, and this is in the respect of a life estate interest in the land, which I mentioned just a little while ago, is the right to use that property for a period of time. And the holder of such is going to be entitled to the receipt of all the income. And there could be, mineral rights on there, could be timber, could be oil, gas, whatever. And it comes from that land, and you have to think about the remainder persons, but the life tenant is going to be able to enjoy those. So broadly, that's real quick and dirty looking at how land could be owned in the And where do we find out, or where do we have opportunity? So as mentioned, some of this land is being held in trust by the United States through federal agencies, namely the Bureau of Indian Affairs and its sub-office, which is the Land Titles and Records Office, which is in bold here, and the phone number is listed there. And this office has these responsibilities that are listed in this here on the screen. They record the land title documents that convey or they can encumber the Indian trust land. And they provide certified title status reports showing the legal descriptions, current ownership, and any encumbrance and liens that may exist, that may be there based on what the owner you may have placed. Maintains the Bureau's official automated land ownership database, prepares probate modifications for Indian probates. This is when we've got the changes moving across families and generations, prepare and or maintain landowner status maps and plats, and then certify land title documents, all part and parcel of this item. Yes, Don.
Hey, Guido, I'm just going to put in the chat the Bureau of Indian Affairs regional office phone numbers too for everyone, because it varies. So this one is specific to our area here in South Dakota. So I just wanted to name that and put it in the chat for everyone.
All right, thank you. Thank you for that.
Yep.
All right. So that kind of wraps up the conversation or the thoughts about titling and figuring out how exactly we have a relationship with these things, with the stuff, and how we might now have responsibility to make decisions about those things and where they go. So moving on with that, we want to think about the 8th issue or something like that, and that is hanging on to stuff. And we all on the call have the opportunity that we can make gifts. Now, I'm just giving the maximum amounts here, and I'm not, by no means do I want to offend anybody. You know, Guido doesn't have, you know, a total estate of what's listed here. But what we look at is what my grandfather would say. He would prefer to give with a warm hand, so he could see what would happen and what might move forward into the next generation. He made a determination. I don't need these particular assets, so maybe somebody can benefit from it. And under present federal law, we've got the annual gift exclusion of $16,000 per donee per year. And then we also have the lifetime exclusion, which for 2022, as you can see listed there, is $2.06 million. So between married couples, a maximum of $24 million could go and be gifted. And those are huge numbers for me, but that's right now where we are at the maximum. But I think the more important managerial thing, or the more broadly, how do we use the stuff, is that we hang on to it and we not put it to good use. And I see my father struggling with this a little bit, because he at 90 is not as physically able to do as much as he used to do. And he wants to be a good steward of the land. He wants to make sure that the land is continually being improved. And how does that happen? And then folks need to kind of figure out what is it that they need for maintaining whatever standard of living that they desire. And in some places, there is the ethical and moral dilemma of, well, we're going to divest the wealth to our family. We're going to give it all away so that the county or the state will pick up long-term care through Medicaid. And there are different options that may be available depending on where we are. But I think the point is, we need to see, do we need all of the stuff that we have right now? Do we need to hang on to it? Or do we need to say, you know, maybe it's better to move it to the next generation and let them use it and then grow whatever it is that they may need to be doing. If we've got some of these financial assets that we talked about earlier, and looking at that list, what do we have? Some of these are life insurance policies. We want to make sure that the beneficiary is correct, that it moves on, that the death benefit is going to go to the correct person. You see right there after the colon, that if we don't change that beneficiary designation, the death benefit could go to an ex-spouse. And I have had that conversation across a kitchen table. And that is not a fun conversation to have when you've had a $300,000 or $500,000 life insurance policy that you thought was going to be coming to benefit you, but because the decedent didn't change who was going to be the beneficiary, left it as a former spouse, well, by operation of law, the life insurance company is not going to make a change there, because why didn't the beneficiary do it? And so you have to say it didn't get done. There were obviously, I have life insurance policies, and about every 2 to 3 years, I get a letter from them saying it may be time to review your beneficiaries. Are you sure you still want to have this person or these persons to do it? The same thing with retirement accounts, other financial accounts for investment purposes. What about installment accounts or installment contracts, rather? These are all financial instruments, and that following the death of an individual, they could move to somebody else. So the tracking of the beneficiaries is very, very important. There needs to be some documentation. Obviously, the life insurance company, the retirement trustee, the bank, and maybe if there's a legal engagement with counsel relative to the installment contract, those would have some records, but they could change over time. There could be an event that may require a change and not updating that ownership, because I don't wish for anybody to have that conversation across a kitchen table saying, this is what the life insurance policy said, this is the beneficiary, and the beneficiary is not you, and that is a problem. And there's no way to get around that, because under operation of law, and what we're talking about is contract law here, the life insurance company is contracted with the individual that owned the policy, and that owner of that policy had the right, he or she, to go ahead and designate who is going to receive those benefits should that life insurance policy come to bear. One item here, and this is probably not as much of a tool to use, but if we do have a large estate in value, then we might want to think about using what's referred to as a bypass trust. But as mentioned in a few previous slides, with $2.06 million excludable in 2022, it's not as needed. But if the estate value does get close to the $12 million value, what we want to think about is, do we want to create that bypass trust so that the maximum amount is going to be able to be protected? We do have something called portability, using the deceased spouse's unused exclusion amount, and that unused exclusion amount is the 12.06 million that we see on the screen. So if I pass away, for example, and have a $1 million estate, then my executor can make an election to take the 11.06 million that remains and transfer it, port it over to my spouse's estate. And so she would have 12.06 plus my 11.06, so that's 23.12 million, and then my $1 million on my side. So between the two of us, we would have $24 million. Again, I know, these are large numbers, but I'm just trying to illustrate a planning thought. And as mentioned there on that next bullet, 99.5% of all U.S. estates aren't going to pay an estate tax. So this really is probably not very useful. But rural landowners may have some issues depending on how land is owned and where that land is owned. If it is in one's own ownership interest, then you need to think about how do I move that over. But if it's held in trust, it may not be part of the estate. What may need to figure out is how that gets moved to the next generation. And just that note that's highlighted, whenever there's a change in administration, just like we had in 2021, then federal estate tax laws and sometimes state tax laws, although many states have repealed estate and inheritance tax. It just depends on which jurisdiction you're in and whether that jurisdiction is applicable in your specific situation. So it could be just a reminder to take a look at it. So we're about halfway through looking at this particular presentation. But one of the things that I've really had to think about and help with folks is looking at getting the right people on the bus. I mean, for those that may be familiar with Jim Collins's book, Good to Great, he has an analogy, an illustration about that you want to get the right people on the bus. And then more importantly, you want to get the right people in the right seats on the bus. So you're going to have a driver, you're going to have a brakeman, you're going to have, whatever, in those things. Everybody has skill sets, and you want to make sure that those skill sets are being used. So if there's an executor or a trustee, who is that individual going to be? Is that individual going to be younger than you as you move forward? Is it going to be somebody that might be outside of the family, or somebody that's there? As I mentioned a little earlier, and I'll just be quite honest, my in-laws asked me about 22 years ago, would I be willing to serve as trustee? And, yes, it's an honor to be asked. They trust you with your skill set. But I can tell you that the past year has not been easy. There have been some difficulties that I've had to work through. Even though they had an estate plan, that estate plan had not been updated for 22 years. And so there are some things that I had to work around. I'm grateful they had a plan, and I'm grateful for the most part that I've had the ability to be able to communicate in a two-way fashion. But there have been some decisions that, had the estate plan been a little bit more clear, it would have saved me a lot of heartburn at how to do that. I'm aware of people that say, yeah, I'll get around to it. Yeah, it's all good. I want to get around to it. Well, maybe what you need to do is go get one of those round to it's, put it in your pocket. And now that you have this round to it in your pocket, then you're going to go do the job. Because I know of people that I will ask folks in a presentation, how many of you have put together a succession plan for your business, or an estate plan, or a combination of the two things? And almost every time, 50 to 60% of the people will raise their hand and say, I don't have a plan. And, it's been said, if you fail to plan, you plan to fail. Thinking about those kind of things. I'm hoping getting folks thinking, yep, I need to think about this. These are some things. What about if there are minor children? Guardian for minor children or disabled family member? It could happen. One thing I'm pretty adamant about when folks ask me, that third bullet down, you want to separate the money job or the financial job from the people job. It takes two different skill sets. Somebody may be really good at managing finances and being able to make decisions. And then there's people that are really good at engaging with other people, being able to be empathetic to what they're feeling or what their needs are. And that is really something that's there. Again, speaking from a personal perspective, our youngest child is a young lady with special needs, and we are in the process of updating our will, one that we wrote about 20 years ago. Now all of our children are adults. Even our youngest child, she's going to be 30, but unfortunately she's not in a position where she's going to be able to take care of herself. So my wife and myself are trying to figure this out, and we are going through the proper steps to facilitate her care when we are no longer available or able to do that. Be certain that you've asked and received agreement from folks to serve in this capacity. I can tell you from personal experience, again, listening to people and sitting around the table, that somebody said, yeah, I found out that I was somebody's executor and they didn't even ask me. And it comes, and it will come at a very inopportune time. It's an inconvenient time, but it's a task that needs to get done. And there needs to be some kind of preparation for contingencies. How deep is the bench? If you want to think about it in the context of an athletic team, yeah, you've got the first string and the second string and the third string. How deep, how far can you go? Do you have that? Or maybe do you just say, I'm going to have to use some kind of professional advice or professional individual? Big thing in the rural community, and maybe in some cultures, it's looking at that we talk about these things is very, very difficult. It's difficult to engage. We may not trust attorneys. I am not an attorney. I have worked with several attorneys over my career. Some of them are very, very capable and very understanding of the individual. Their doctors, for example, some folks would rather go to the vet than to go to a doctor. They figure, hey, the vet at least knows different species. The doctors maybe not so much, but I look at that, and it's a matter of trust. It's a matter of how do I communicate, and then how do you communicate to the executor before your passing, saying these are some things that I want to look at. How do you communicate with the trustee? What about the beneficiaries? We'll have these documents if the documents are drafted and the documents have been brought together and brought in place to be used. And that's a way to communicate, but nobody likes a surprise, and sometimes being secretive is a way to do it. I don't want to say, hey, I'm going to go stand on top of a mountain, or I'm going to go rent a big billboard on the street and say, hey, this is the way it's going to go. And I have come over, again, 35 years to think about talking about wealth, talking about money. And it's not necessarily, but talking about these things within a rural community or in a cultural community, it can be seen as being rude. It can be seen as being taboo in some cases. But there does need to be, in my view, some communication. It may be just that we have put together a plan. Y'all don't need to worry about it. The plan is there, and in due time, you'll know what the plan is. Or you can say, we're going to have Sunday dinner, and we're going to have the kids over, and we're going to say, this is the plan. We've done it the best way we can. We've done it the best way that we know how. And we hope that we have not hurt or upset anybody, but you wanted to kind of figure it out. And this is where it's going to go. The family needs to talk, and they need to talk before it's too late. I like to say you need to do it a year before you think you need to do it. At least get it going, because automobile accidents happen, strokes happen, those kind of things. And if you're going to have a big family meeting, then sometimes you might want to have it with an outside facilitator. And I've done that a time or two with some families. I've kind of acted as the facilitator. I've also engaged a facilitator who had some special skills to go through and say, this is something that's needed. In my in-laws case, there was some secrecy. I came into knowledge over 22 years prior to my father-in-law's death, but I was requested to keep that to myself. In my family, my parents write letters to all 5 of us kids. It's the same letter. We all get it roughly at about the same time. And it basically, dad will say, blah, 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 blah. And mom will say, well, I don't agree with that, but I'm going to have it this way, and back and forth. But at least we communicate, and we all have some kind of knowledge and some kind of baseline. And email today in 2022 is a really nice way to level that potentially. But think about that, looking at that communication. And it doesn't have to be a tell-all. It can just be, I have done something. You don't need to worry about it. I have sought counsel. I have made the best decision with the information that I have. And in due time, you will see that. So again, talk and make your wishes known. This happens to be a photograph that I took of my father. This, as I said, this photograph is 15 years old now, I guess. I think my dad turned 90, and this is on the farm that he has and that he manages. And this was taken about this time of year. As you can see, the grasses are turning green, golden, and the sumac that's there is kind of the reddish leaf stuff. But he and I spend a lot of time anymore. I do all the fence repairs as it goes through, but he's struggling with how does this property, how does it move to the next generation, if it moves to the next generation. But he's trying to make his wishes known, but he's also trying to be realistic about what's going on. As we move through and we're kind of winding down some of these thoughts, and hopefully some of these are reaffirming or confirming some of the thoughts that folks have had online, that they're not, you want to review your estate plan, and you want to, rules and laws change, and you'd like to at least look at the plan, I think, once every 3 years or so to ensure that it's still doing and it has the opportunity to meet the goals that you've set out. Generally, you want to review it after a major federal or state law change, or if there's been a presidential election, as I mentioned earlier. And there are circumstances that are going to change and that you can correct for those points. There could be a divorce within the family. There could be a major illness. There could be a disability. There could be births. There could be deaths. Those kind of things as you move through. How does that succession plan, how does that estate plan, and really succession and estate planning work hand in glove together. It's what's going on. Succession may be more of the transition, while you can be a mentor where you can say, this is how this is going to move, and you might want to change. But if you review those plans, then you have the opportunity to make some corrections or to make some changes because of fact patterns that have occurred that might require that particular change. And as we move through number 2 here, moving into the number 1, is that sometimes folks fail to have advanced directives. They have a living will, which is going to allow for natural passing. However, that wants to be there. Be sure that there is agreement with those concerned. I have a friend of mine who had a living will, had a medical emergency, was deemed to and was placed on life support. The individual that was charged to make the decision was her spouse, and he just felt he couldn't do it. All the indications based on her instructions, based on her communication through the living will, said, when this happens, this is how I want it to be handled. Well, he couldn't do it. As it happened, he probably maybe had this inkling, having been married for quite a while. Anyway, long and the short of it is, she recovered and they've continued to enjoy life together. She was still a little bit mad that he didn't listen to her at that last little bit, but maybe that's that spousal thing. You also want to have that durable power of attorney for medical, and you want the durable power of attorney for financial needs to make sure that those items are helpful and in place so that if one becomes incapacitated, that those needs, those things are going to be taken care of in an orderly fashion. So this moves us into the number one mistake in estate planning. This is a big oops, perhaps, but that number one, in my view, and in reading a lot in this particular area, is that the individual does not have an estate, a succession, or a transition plan of their own making. It's incorporating their own design, their own choices. And really the issue, the difficulty of, I think, any estate or succession plan is this first bullet. This is really the toughest nut to crack. And that is, who's going to get the stuff? When are they going to get the stuff? And how do they get the stuff? And if you don't have a will, then the rules of intestate succession, and generally citizens of each state fall under these rules of intestate succession because the state has a way. It's called the rules of intestate succession. Intestate just means without a will, without any direction, and that is to deal with the stuff. And there's a set of rules, and all the states are somewhat similar. In some states, the surviving spouse gets half. In other states, the surviving spouse gets a third, depending on how many kids. In North Carolina, if there's a surviving spouse and no kids, she gets everything. If there's a surviving spouse and one child, she gets half. If there's a surviving spouse and 2 or more children, she gets a third of the assets, and the children get the remaining 2/3 to split amongst themselves. If that's really what you want, fine. You don't have to go do anything, but probably that's really not how you want to have those things moved. And then if you think about the changes in family circumstances, as we're all living longer, we may have those. Then you look back at the item number 3, which was a few slides earlier, looking at those changes. What's happened? What's going on? Do they need to be positioned? That's really what you're thinking about, is that, and this is really what Dawn has asked me to just provide some thoughts about today, is looking at this and saying, thinking about what are some things that you want to look at? What are you want ticking the box? What mistakes do you want to avoid? And hopefully these 10 ideas get you to this one, and that encourages you to make your own plan. Because if you've made the plan, and if you sought sufficient counsel, good counsel, then the transition typically runs pretty smoothly. It's going to take a little bit of time. It's going to be somebody's in charge, and they make sure that the I's get dotted and the T's get crossed, but it moves forward. This is a quote that I heard at a presentation about 25 years ago. I really think that it's nice. It says, the issue regarding estate planning is that nothing wrong has been done. It's that nothing has been done, and that's wrong. So it's just an encouragement to go ahead and put it together, which follows down at the bottom is one of my attorney friends brought this to my attention, and not that he was self-serving. He was an attorney in the extension service in Texas so many years ago. He said, help me is much cheaper than fix me when we look at engaging legal counsel. Going in the front end, yes, it's going to cost a little bit, maybe $300-400 for a simple will. Depends on the location. Sometimes there's opportunities to get it done through banking system or through a credit union that, for a nominal fee, it's more service being provided to the clients and customers of the bank or of the credit union. And you can get it done relatively inexpensively that way. But Help me is much cheaper than fix me when we look at attorneys. And then when we think about particularly farm assets, and it depends on how these items are, we want to think about these land transfers, because that's generally where a lot of value is in farm estates. Now, it could be through the use of gifts. It could be through the use of landowning entities, such as an LLC, limited liability company. There could be a will or a trust document. And I'm referring to some of the earlier slides. There could be some special circumstances where the land is held in trust for beneficiaries. But the beneficiary of the trust has some responsibility to look at what happens when they may pass on, and then come to the decision as to who's going to get what. And at this particular time, remember that a non-decision becomes a decision. So how is the property? How are these things? How is the stuff owned? How do I engage with that stuff? What rights do I have to that stuff? And what rights do I have to move or to designate who might enjoy the benefits of those assets into the future? And that's where it takes very competent legal help to get that done. So as we're wrapping up here, looking at this particular conversation, and in summary, we go back to this particular screen. And I want to start at this time, I want to look at plans at the lower right. So we've been talking about plans, thinking about what additional resources, if needed, what retirement income, how do we define retirement? That's things people may think about that. Yes, I've retired from North Carolina State University, but I work part-time for, as Dawn in her introduction said, for Iowa State University. I also do a little bit of consulting down the road. And I've always looked at retirement as just like putting new tires on a car. You retire the car and it is good for another 50,000 miles. We don't necessarily stop doing what we're doing. We want to look at updating the estate plan. What about this? If we are operating a farming business in the context, who's going to be a successor? Is there anybody identified as the successor? Is it a son? Is it a grandson? Is it a daughter? Is it a granddaughter? How does this work? Is there going to be a sale? Looking at that, how does all of this put together? So when you look at the plans, then I'm going to go back and look at the stuff. That very first slide that we had was looking at what's the listing. Do we have our liquid assets, our cash in the bank, our non-liquid, looking at land, business resources, the equipment, the cattle, the livestock, the people, who's engaged in the land, the management of the land, who wants to be involved in the land? Are there any special circumstances as we've talked about this? Is that current estate plan in place? And then it finishes up. Do all of these things match up to the goals that we have, as you can see in the upper right? Do they answer the questions? This is what you want your life to be like in the future. Or is this what you want for your family in the future? And what do you want to have happen to this thing, these things that we call our stuff in the future? How do they move forward? How do they go? And it may be just very simple. I'm going to leave everything to my eldest son. I'm going to leave the jewelry to my eldest daughter. End of story. Or if you've got 6 kids, that may make it a little bit difficult. Decisions have to be made. And as I mentioned in 2 previous slides, if you don't make a decision, that in and of itself is a decision. So Dawn, that kind of wraps up my thinking, some of my comments and thoughts relative to this. I thank the folks that have been watching and listening, and I hope that this has been helpful. But are there any questions or anything that I might need to clarify?
Thanks, Guido. I don't see any questions in the chat, but if any of the attendees would like to place some questions in the chat, now's the time to do so. I'm gonna allow folks to talk if they want to unmute and ask some questions out loud. Just raise your hand and we'll call on you.
I'm
I'm
going, I'm
sorry.
going to, I'm going to stop sharing and just open it up.
Perfect. Thank you. I had questions throughout the entire presentation. It was very thorough. Every time I wrote down a question, you answered it. So I marked it off. But my one question that maybe I just didn't hear was, what if someone does have an estate plan or a succession plan and it was just like, unfortunately, you know, like there's cultural sensitivities and things like that, and it was just never taken care of and something happened, so it was never signed off on.
Okay.
Do you have any advice for that?
Well, it always ends up with, it depends. Okay. So let's put a little flesh on this. You've got a plan, and I guess in the legal sense, as I would view it, is that plan was never executed, in that it wasn't signed, it wasn't witnessed. We just have words on a piece of paper. We didn't go back and get it done, right? But it does, if it ends up in, and more than likely what happens, it may end up in court. Some jurisdiction will look at it and say, okay, so Guido died, but he didn't execute, but he was working on it. This may give the court a view or thinking of, this is how he was approaching this particular issue. Now, it has no binding because it wasn't finished. It wasn't executed. Some jurisdictions, what they'll do is you execute your will, and then you go and you register it with the clerk of court in the county in which you live. And so that notifies the legal system, that notifies the probate court, we've got something over here. Now, if I die, they may look at that and say, okay, we've got this. The other thing that sometimes happens is that there may be, for the lack of a better term, a letter of last considerations or a letter of last wishes. And it may be just, here's what I'd like to have in my funeral, right? This, you know, these kind of things. And you kind of do that. That's more to the family, and it's probably not held in a safety deposit box, because if there's needs to be timely answered, then you need to go and figure that stuff out. So the answer really, Dawn, is it depends. You hope that folks will go and execute. My wife and I, just again, personally, our will is 20 years old. 25 years old, actually, now. It was written when all of our children were minors. Well, all of our children are now adults. We've got, 3 married kids, and we've got our youngest, and we need to rehash that, because what we decided 25 years ago isn't, it'll still work if something would happen, but not as easily. I don't know if that answers your question or helps you.
Yeah, it does. Thank you for that. Is anybody, I saw a few people unmute. If you'd like to ask your question out loud, that's fine. All right, well, no one's unmuting, and we have given that option. So thank you, Guido. That was informational, and thank you for naming the cultural sensitivity around things. It's very important in our communities. I want to go ahead and close this out by thanking everyone for joining us today. We do have a feedback survey that we like to offer out to everyone. We want to be able to provide you all with webinars that are helpful and beneficial for your agriculture operations. So I'll place that in the chat, but it will also come in the email. We have another webinar coming up next month with the Iowa State University as well, and that's going to be with Ms. Tover Jensen Kit with the Center of Agricultural Law and Taxation. It's going to be named Legal Pitfalls of Estate Planning. So everyone is welcome to register for that as well. Is there anything else you'd like to add, Guido?
No, again, I just want to reiterate, Dawn, thank you for the opportunity, invitation. If folks have a question, they have, I think my email has been provided to them. They're either through my personal email, which is a Gmail account, or through Iowa State, or you can get it through Dawn. Dawn can get a hold of me. It just depends. Sometimes these questions are rather personal, and they may not want to have ask them in a I just offer. That's all I'm doing. Just offer. I can react. And again, I'm not an attorney, but I have worked with farm families over the past several years.
Right. Awesome. All right. Well, thanks everyone. Have a great day. I have placed our contact information in the chat, or you can reach out to us via email. All right. Thanks again. Have a great day.